Good evening, my friends. I hope everybody's doing well. It's great to see you guys. Happy Friday. Yeah, man. We're going to I have not read these documents. I have not watched anybody cover them in full. I've seen a few posts on social media. But I am going to read some of these documents myself. And just seeing some of the posts that I've been seeing. I mean, I know Meredith has been tearing this stuff apart on Twitter or X, and which reminds me, for the 100-something of you watching on X right now, thank you for watching. It's great to be back. I can't believe it. They have restored my Twitter account. I cannot believe it. Yeah. It's pretty amazing. I'm really happy about that. Because like it's really weird because everybody kept saying like, "Yo, make a fake account." You know? I don't do that. Like I don't do that. I have an alt account on YouTube with maybe 800 subs. And it's just in case for some reason I can't stream on this one. But I do have an alt one, but it's called Galera. So I'm not like hiding. It's not a troll account. I don't make troll accounts. And I've said this many times before. The main reason I don't make troll accounts is because I want you to know who's insulting you when I insult you. I want you to know it's coming from me. Like right here. Okay? Like when I insult you, it is with feeling. Even maybe with a little bit of love. Okay? Because I don't hate nobody. You know what I mean? But I do like to call out some stupidity sometimes. But yeah. So yeah, I don't make troll accounts. I just don't do that. And I'm too lazy to do it too. Like it seems like a lot of work just to be like, fuck you. You know what I mean? Like having to like create this whole new thing on Google. I'm good. So yeah, man. Next week is gonna be wild. Next week you've got the hearing on Tuesday, then on Wednesday you have a hearing, and then the what do you call it, the federal hearing with Weinberg, and then you have another hearing and you have Turtle Boy's hearing. So yeah, a lot going on between Tuesday and Wednesday. A lot going on. And I wouldn't be shocked if there was a surprise or two. But yeah, there's a lot going on. But what I'm gonna do today, we're gonna go over some of these motions because this is okay. I have to just, and real quick, let me give a big shout out to Mazza Media. Mazza Media did a 3-hour fundraiser yesterday for Karen's birthday, a belated birthday bonanza, and raised over $4,000, and got the overall total in the defense fund for Karen Reed past $725,000. $725,000, people. Amazing. Mazza is the man. Much love to Mazza Media. I'm your favorite X person. That's crazy, man. I am gonna watch my step a little bit now because the thing is they're like everybody's reporting me. Like the trolls are so mad that I'm back on Twitter. And what's really funny about it is I was like, all I did Seriously, like all I did, like they give you the option to appeal. It's the weirdest thing. It's like I still had an account, but it was permanently suspended. Those were the words that X used. Your account is now permanently suspended. You cannot post, you cannot like, you cannot engage in any way whatsoever with anyone on Twitter. I couldn't DM anymore, nothing. And so, but the thing is I like all my followers, like I guess the algorithm and whatever of everything that would show up on my feed normally still showed up. So I just kept going. And every time I got on there, it would say your account is currently permanently suspended, blah, blah, blah. And then, but it gives you an option to appeal every time, right? I appealed like at least 8 times. At least 8 times I appealed. And the more I did it, the less I gave a fuck about how I worded it. Because I honestly, this is how insane I am, by the way. I thought, okay, I've already like used to not having a Twitter. I'm getting used to just not even having to engage. It's whatever. I could still keep up and see things and it's whatever. But I kept appealing and then I stopped giving a fuck, but I kept appealing. And it got to a point where I was just like, yeah, so you know what? I guess Elon's not all about freedom of speech like he says he is. All because I told somebody to go fuck their mother. Real nice. America, good job. Some sarcastic shit like that. And then I get an email saying your X account is now restored. So I was like, fucking America, dude, because if my account was going to get restored, it was going to be under those fucking circumstances. It was going to be under the circumstances of me being as fucking honest and raw as I possibly could to Elon, and Elon being like, you know what, dude? Cool, bro. I like to believe, okay? Y'all can fuck off with your dream wrecking, okay? But I prefer to believe Elon saw that shit himself. And he was like, all right. It just makes me feel better to believe that. Okay. It just makes me feel better to believe that. So because it would bug me, man. I liked Elon when it happened. I even defended his Zeke Heil. I even defended it. I asked questions and I explored it, but I explored it fairly. Okay. But I drew the conclusion that it was innocent. It was just, he should have like known better. You know what I mean? It was like, come on, bro. You had to know. You know what I mean? Just, there's no way around the fact that it looks like a Zeke Heil, dude. You know what I mean? And you're at a Trump inauguration party and you're celebrating a fucking sweep of an election and you're about to like do the most unprecedented shit that anybody in any presidency has ever done. Like, these are insane times, and Trump is like real pen happy with these executive orders like he was last time. And it's fine. Like, I'm not complaining about it, but it's unprecedented. It's never been any fucking thing. There's never been anything like it. And it's wild. So far, I'm actually glad to be living in these times because things are going pretty good for me. So I'm not gonna complain. But yeah, it was nice to find out that somebody on Twitter was just like, yeah, fuck it. I'm just gonna fucking restore this dude's account. Who gives a shit? And I got my monetization back and everything. It's amazing. But I'm still a little rusty. I'm still a little rusty. Because I haven't engaged with anybody on there in a while. Now let me go over this shit real quick. Hold on. No, bro. No, bro. Here we go.
I'm investigative reporter Ted Daniel. Karen Reed has tried to get her case dismissed.
So, y'all like, what's going on with Ted Daniel? Do we like Ted Daniel? Do we not like Ted Daniel? What the fuck's going on? I mean, like, because the thing is like I saw the Twitter exchanges between him and Turtle Boy. I think it was him and Turtle Boy, and he was like, the investigation, Ted Daniel definitively said the investigation is closed in that thread, right? But Turtle Boy sources say otherwise. Now, here's the thing. I like Ted Daniel. Okay? I like Ted Daniel. But Ted Daniel, as crazy as this is going to sound to him, most likely, Ted Daniel doesn't have the record with me in this case that Turtle Boy does. You see what I'm saying? Turtle Boy has consistently been correct and has reported things without fear this entire time. As much as I love the interview that he gave Karen Reed, as much as I love it, I gotta say, if I'm choosing credibility overall when it comes to information on this case, Turtle Boy has earned it by a landslide. Let's just be honest. Like him or not, he has. He's been correct about everything. He brings receipts with everything, right? So, and I get it, you know, but, and also really, I'm not going to lie too. I really try to like really practice self-awareness, you know, and I got to say that my leaning that way has a lot to do with just having sheer hope that the new U.S. attorney is not going to just blow this off. It doesn't make sense to me. It does not make sense to me that Liza Little would say it in court, and then after the fact, conveniently, Brennan gets notified that state and local law enforcement got calls from the U.S. Attorney's Office saying, hey, you guys are good. Like, that doesn't happen. So I'm having a hard time believing that. And it also makes perfect sense to me that Ted Daniel, like, it was strategized for it to leak through him. They wanted to leak it to him. If it's a lie, okay? If it's a fucking lie. But I have every reason to think it's a lie. I mean, look who it's coming from. But I would speculate that it was strategic, and the timing is just too coincidental, but it was strategic to feed that leak through Ted Daniel. Simply because these interviews with Karen Reed are all the buzz. If I were a dirty motherfucker working for Michael Morrissey's office, this is the move I would make. I'd be like, all right, so he's got sources, right? So let's get these sources. Let's get these sources to leak this shit to homie. You know what I mean? Now, maybe that's a little dramatic. maybe I'm full of shit. You know what I mean? But I don't know, man. It just seems like the timing seems too coincidental.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
Mary Rothman, thank you so much. I think Ted Daniel it's no S at the end. Ted Daniel got set up. Betty is pissed. Yeah, I don't know about all that. I'm just saying, it makes sense to me. Look at the shit these people have done already. Is it that far-fetched? Think about it. Look at the shit these people have done already. Fanning was in charge of the fucking jury, dude. And I'm supposed to put it's paranoid and it's insane and it's far-fetched to speculate that they deliberately leaked this FBI investigation after it was brought up at a hearing. And then conveniently, these phone calls come in. But they didn't call the defense to let them know. And then Bev is like, I'm not going to ex parte call. Okay. Like, can you call them to a hearing? I wonder if you could do that. Because I'd like to know, you know? I just don't see my whole thing is I don't see feds doing that shit. Feds don't do that shit. Feds don't call you up and go, yo. I mean, that's crazy. Yo. I'm free. Yeah. You know what that means. You're off the hook, my man. All right. Just keep doing. Go back to doing whatever the fuck you was doing before, man. Peace. That doesn't happen. Like, I've never heard of them. Like I've never even heard of anybody like closing an investigation like that. Like, that's why they have such a high conviction rate. Is like they're always collecting evidence. Everything's always open. They don't just shut off an investigation. Like, not with a case like that. Because what you're trying to catch them on is all kinds of different crimes. There's all kinds of shit that's wrong with this case. All kinds of shit that Michael Morrissey's doing.
Multiple times in multiple courtrooms. Her latest attempt is in this filing, and it's the most aggressive yet.
147 pages, some completely blacked out. What we can read is blistering. Reed's defense accuses her courtroom adversaries of gamesmanship and pervasive misconduct. Defense attorney Peter Ellikin provides legal opinion for Boston 25.
These are the strongest ethical accusations you can make against various players in the government.
Reed's Lexus was towed to the Canton police station. The defense claims video of the SUV was withheld and...
Look, man, they accused him of shit the last trial too. There was a motion to dismiss and disqualify Morrissey. But I don't think it was under extreme misconduct, governmental misconduct.
And manipulated, including the inverted video from the garage shown at her trial. The defense claims there can be no doubt that this video and false testimony was offered to mislead this court, and it is not a coincidence that none of the many cameras captured the condition of the right rear taillight upon its arrival at the CPD.
That they said every time the camera gets near that taillight, it's suddenly cuts out.
Some of the blacked out sections are about an excused juror, the specific allegations hidden. But the defense argues a juror may never be dismissed because of their views on the case or for reasons having to do with their relationships with other jurors. Prosecution witnessed Jennifer McCabe's relationship with Canton Police Sergeant Michael Lenk, and McCabe's cell phone activity is also included. McCabe is the one who Googled how long to die in cold. Experts from both sides continue to fight over the timing of that search. The defense alleges that McCabe took steps to delete that one search out of more than 4,560 on her phone, along with every communication on her phone in the hours following O'Keefe's death.
So what the defense is saying really is that the only remedy here is to dismiss the entire case.
That's now up to Judge Beverly Cannoni to decide. She's denied all of the defense's previous attempts.
Yeah, I was going to say, Ted, how did you do this without laughing out loud when you said that?
To get the case tossed. I'm Ted Daniel for your local station, Boston 25 News.
Dude. Wild, bro. Hopefully. All right, so let's go over this shit real quick. Oh, fuck yeah. Hell yeah, bro. Defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. Now comes the defendant Karen Reed. Ms. Reed respectfully moves this honorable court pursuant to Article 12 of the Massachusetts Declaration of Rights, the 5th, 6th, and 14th Amendments to the United States Constitution and Massachusetts, blah, 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 to dismiss all charges with prejudice on the basis of extraordinary governmental misconduct. Blah, 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 of the Declaration of Rights in the Massachusetts Constitution. A prosecutor may strike hard blows, but he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. Berger versus United States. Throughout the course of these proceedings, Ms. Reed has been severely prejudiced by the Commonwealth's pervasive misconduct. The Commonwealth has suppressed discoverable and exculpatory video surveillance footage from the Canton Police Department, CPD. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started and after the Commonwealth represented that all video footage had been provided to the defense. For reasons that remain unexplained, much of the video that has been disclosed is missing critical timeframes and evidence central to Ms. Reed's defense. Some of the video clearly appears altered or manipulated, as evidenced by people appearing and disappearing out of nowhere. Bunch of Plevin attic dwellers, but in the Sallyport. At the first trial in this matter, Assistant District Attorney Adam Lally, ADA Lally, brazenly introduced inverted video and elicited patently false testimony from Massachusetts State Police Sergeant Yuri Bukaki, that the video was a fair and accurate depiction of critical events, and in attempt to falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the right rear taillight of Miss Reed's SUV. There can be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor was standing next to the left rear taillight when the Commonwealth knew the exact opposite was true. Trooper Proctor was, in fact, standing directly next to the right rear taillight. Other Sallyport video, which was unquestionably favorable to the defense because it would have severely discredited key witness Brian Higgins, inexplicably was not disclosed to the defense until months after the first trial. This day, the Commonwealth, I guess it was because he was on the phone. I guess that's what's redacted. I don't know why. Circumstances surrounding their disclosure of the exculpatory Sallyport video and why some video was suppressed from the defense at the first trial has made a mockery of Ms. Reed's right to due process. The Commonwealth exploited this court's order instructing the defense to disclose its impeachment material in advance to witness testifying. ADA Lally and MSP Lieutenant Tully huddled with key witness Jennifer McCabe mid-trial, prepped her on how to explain why she never disclosed that she went to CPD Sergeant Michael Lank's home one day after John O'Keefe's death, and then suppressed exculpatory statements made by McCabe during that session until nearly a month after McCabe's testimony, at which point McCabe and other relevant witnesses were safely off the witness stand. If the Commonwealth had complied with their obligation to provide statements of witnesses before they testified, the defense would have been positioned to expose McCabe's inconsistent statements about her meeting with inconsistent statements about her meeting with Sergeant Lank. Wow, a lot of this is redacted. As a result of this extraordinary governmental misconduct, Ms. Reed has been permanently and irreversibly denied her constitutional right to a fair trial. This is 100% true. No remedy other than dismissal can adequately address the significant harm caused to Ms. Reed and the injustice of proceeding without the lost exculpatory evidence that was in the Commonwealth's possession. Accordingly, the case against Ms. Reed must be dismissed with prejudice. Statement of facts. Ms. Reed is accused of the following crimes arising out of the death of Officer O'Keefe: murder in the second-degree violation, manslaughter while under the influence of alcohol in violation, blah, 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 and leaving the scene of personal injury and death. A months-long jury trial was held in this matter beginning on April 17th, 2024. On June 25th, 2024, the jury began deliberations after the jury submitted a note to the court indicating that the jury was at an impasse. The court declared a mistrial on July 1st, 2024. The Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury in a case in which the jury either voted to acquit or was deadlocked on the lesser of one charge. There is no cure short of dismissal with prejudice that can remedy the serious constitutional and statutory violations that have occurred in this case. The facts relating to the representative misconduct and discovery violations are set forth below. Real quick, let me read this footnote. In the days and weeks following the first trial, first deliberating jurors have come forward and indicated that they had unanimously acquitted Ms. Reed on counts 1 and 3 and were hung only with respect to count 2. They indicated that they did not believe they were permitted to report the unanimous decisions on count 1 and 3 unless they were able to reach a unanimous verdict on all counts. Ms. Reed's failure to address any claims of double jeopardy in the instant motion to dismiss shall not in any way be deemed or construed a waiver of those issues, which are presently pending before the United States District Court for the District of Massachusetts. Facts relating to the destruction and withholding of exculpatory CPD video surveillance footage. Now, there's a lot of pages here, so I'm just trying to I just want to get through as much of it as I can. But if I read something obviously that really snags my attention and gets my wheels turning, obviously I'll take a break from it and discuss it. But in the meantime, I'm just kind of going through it here. The court is aware of the critical importance of the video surveillance footage from the CPD on January 29th, 2022. The Commonwealth has produced dribs and drabs of various clips of video surveillance obtained from the CPD's ExecuVision DVR system from January 29th, 2022, without any accompanying reports, evidence logs, or other documentation regarding the recovery and chain of custody of this evidence on at least 4 separate occasions. Relevant discovery orders. On February 2nd, 2022, the defense filed defendant's emergency motion for preservation of evidence, including the preservation of all physical evidence, such as video surveillance footage, with the Stoughton District Court, Exhibit A, February 2nd, 2022. Order on motion to preserve evidence at February 2nd, February 2nd, 2022 hearing, ADA Lally stated in open court that he had reviewed the proposed order and had no objection to it. That same day, the district court issued a preservation order for all physical evidence, which includes video surveillance footage. Now, just to paint this picture a little bit more colorful for you guys, this is February 2nd. John O'Keefe is killed on January 29th, 2022. This is February 2nd. Okay? And Karen Reed is being arraigned, and David Yannetti, the cerebral ninja, as I like to call him, had the foresight to put this on the record, file a motion requesting that they do this so that there's no reason whatsoever that they would not share all the evidence. That was the whole purpose of it. You know how I know that? Because David Yannetti told me that to my face. He said that was just in case they tried to pull something like this. That's what he said. I was like, wow. Because I was amazed. I was amazed at the fact that he had the foresight on the 2nd to do that, because he knew. I had to ask him. I was like, that just tells me that you knew something really dirty was going on. He was like, absolutely. I've never heard anybody answer with such certainty in my life. He was totally, absolutely. And so here we are 3 years later, and Lally has not done this. Trial was last year, and they just busted out with new footage right in the middle of the trial. After how many motions to compel for discovery filed pre-trial to trial 1.0? How many? I mean, an insane amount. I don't even know how many it was, but it was a lot. And Bev just was like, whatever. So, I mean, let's just get real here. Like, there's something really dirty going on here. I mean, what I don't know what, dude. And when the only people who think that Karen Reed is guilty at this point and are saying that she is, the only people are the worst fucking people that you've ever met or seen in your life. They're always the worst fucking people, dude. Just bad, shitty people. That should tell you, I mean, that speaks volumes. It speaks absolute volumes. People with no sense of accountability, no self-awareness. It's people with a sense of entitlement. People who just prefer to waste their energy on hating people. I mean, dude, listen, I give everybody the benefit of the doubt. That's how I look at true crime cases. I am never one of these bandwagon jumpers. I am never one of these pitchforkers who, you know, I'm never one of these people. But when somebody's fucking guilty, man, they're fucking guilty. Do I think Brian Koberger's guilty? Totally, I think Brian Koberger's fucking guilty, dude. Do I think that Brian Walsh is guilty? Fuck yeah, I totally think that Brian Walsh is guilty. What's up, Olivia Nile? Homie. Yeah, dude. Like, you know what I'm saying? Lauline. Dude, you know, but like, I always, like, before I come to these conclusions, I look at the evidence that's made available to me. I looked at the evidence made available to me with Brian Walsh, and I was like, oh, this motherfucker totally did it. Like, this motherfucker is guilty as shit. You know? I mean, everything about Karen Reed's case is like the fucking polar opposite. Same lead investigator, completely opposite approaches to collecting evidence and conducting an investigation. Dude, you could set your watch to the Proctor investigation into Brian Walsh, bro. You could fucking set your watch to it. This isn't negligence. This is corruption. That's all this is. Governmental misconduct up the fucking ass, dude. An insane amount of governmental misconduct. I've never seen so much governmental misconduct in my life. I don't understand why the whole country is not talking about this case right now. I'm lost at this. Crazy. Let me keep reading here. Okay, there it is. In other words, 3 days after O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in possession, custody, or control, which included the CPD and or the Massachusetts State Police, and ADA Lally was required to notify law enforcement of this order.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare
Kim, thank you so much. Wow. As a lawyer, I see it this way. The longer the case goes on, with more Commonwealth casualties are exposed, and acquittal would be detrimentally to the Commonwealth. The Commonwealth is setting up to blame the defense of dirty tactics for dismissal, but don't worry, we got the girls. Okay. Thank you, Kim. I love it. Dude, let me tell you guys, man, how validating it is, bro, when lawyers dig my channel. You know what I'm saying? Like, it's validating as fuck. It's awesome. You know? They're like, yeah, I'm going to watch the Glare and his GD ass fucking analyze this case. Fuck yeah. You guys are awesome. Laura H, thank you. Welcome to Logic. Wow. On September 16th, 2022, after Ms. Reed's case was transferred to Norfolk Superior Court following her June 9th, 2022 indictment, the defense filed a separate motion to compel the production of certain outstanding discovery, including all crime scene photographs and or videos taken in connection with this case. Motion to compel on October 5th, 2022. The court granted the motion to compel in part and ordered the Commonwealth to produce all video evidence metadata associated with the videos on that date. There's a motion to compel right there. In 2022, bro. You know what I'm saying? Dates of production and facts relating to discovery and constitutional violations. The CPD's video surveillance footage has been in the Commonwealth's possession, custody, and control since January 29th, 2022. Notwithstanding this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years, failing to disclose even the first incomplete batch of the footage until the eve of the first trial on April 4th, 2024. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded at the CPD on January 29th, 2022. That is 4 separate and incomplete batches of video. It is a very simple thing that the defense is asking for. The complete video. Otherwise, it's no good. If it's chopped into 4 pieces, then you have to assume that it's been fucked with beyond that, because it shouldn't have been fucked with. So what they should have is the 24-hour metadata, or the evidence is no good, or it's doctored. I mean, it's real simple, which is why I'm saying this is a Bev thing, dude. This is clearly a Bev thing. I don't give a fuck what anybody says. This is a Bev thing. Like, she's allowing these things to happen that should not be happening. I have never, ever, 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 ever seen a case where a judge would put up with these kind of shenanigans from the prosecution. Never in my life. Especially in a high-profile case. This is insane. I mean, the bias is so fucking obvious. It is incredibly obvious. How many motions to compel does it take? These people have failed to produce discovery. And all Brennan has done is double talk his way around it. Metadata. I mean, they keep talking about, they keep saying metadata this. It's, dude, metadata is exactly the key thing that establishes validity to that evidence. That's it. That's what the metadata is for. It is vital to authenticating the evidence. You dum-dum. And he's not a dum-dum. He's just trying to dismiss it and make it seem not important, so that when Bev makes it seem not important, then it's all good. Plays it off like as if it's just a normal thing that would take place in a trial. There's no fucking way, dude. Anybody who owns a fucking cell phone, dude, I don't give a shit if you're Bev and you're probably tech stupid, but I'm tech stupid. And I know exactly how important metadata is. I know that without it, it's not real. It's not real. How do you think Turtle Boy was able to prove that Clay was a fake baby? Baby Clay, Clay Strong. Because the metadata on the picture proved that it was from another pregnancy years before. Fake victim. Think about that. Metadata is like video and photograph DNA. Basically what it is. It's DNA. It shouldn't be difficult to provide it. Just the shenanigans alone that took place from their expert going to the Canton PD, and this woman acts dumb, even though she directly spoke with someone on the defense team. They arranged this time, and she works for Michael Morrissey in the Norfolk County DA's office, but she's at the Canton PD at the time they're supposed to meet there. And Bev is just like whatever about stuff like this. That stuff doesn't happen in other cases. I have been doing this long enough. Five years is not that long, but it's long enough to know that this is some fucking fuckery taking place. And the judge is accountable. The judge is to blame. Judge Beverly Cannoni is absolutely to blame. She's allowing this circus to go on. Like, if anybody lives in Massachusetts and your tax dollars are going to this, you should be pissed. You should be so fucking pissed. Wow. Okay. April 4th, 2024 production. On April 4th, 2024, on the eve of the first trial in this matter, the Commonwealth, for the first time, disclosed woefully incomplete CPD video footage, which consisted of video from the CPD main driveway and CPD Sallyport front wall cameras from January 29th, 2022. Curiously, the Sallyport front wall footage omitted a 42-minute interval at the precise time the SUV arrived at the Sallyport garage. Yeah, that's an interesting coincidence, right? Coincidence number 3,427. Sallyport front wall footage. The missing footage from the Sallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the CPD Sallyport garage. But the individuals who had access to the right rear taillight and whether anyone removed taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road, the condition of the right rear taillight of the Lexus SUV at the time it entered law enforcement's custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way, in violation of the February 2nd, 2022 preservation order, which means that the defense has been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost critical video evidence in its possession that it was obligated to preserve. That the Commonwealth was obligated to preserve. April 10th, 2024, the Commonwealth files its certificate of compliance. Oh, shit. Oh, shit. Okay. On April 10th, 2024, the Commonwealth files its certificate of compliance. On April 10th, 2024, the Commonwealth files its certificate of compliance in which ADA Lally certified to this court 6 days before trial at the Commonwealth after exercising reasonable inquiry and due diligence to the best of their ability, disclosed and made available all items subject to discovery. Exhibit F, April 10th, 2024, certificate of compliance emphasis added. The representation was patently false. It strains credulity that ADA Lally, in the light of his actual knowledge of the preservation order and existence of extensive Sallyport video, would represent to the court and to the defense that after reasonable injury, he disclosed and made available all known, discoverable material in his possession, custody, and control, at a minimum, rather than mislead the court and the defense. ADA Lally was obligated to inform the court and the defense that there was outstanding video surveillance footage. Party may not fail to make reasonable, diligent effort to comply with a legal proper discovery request. April 23rd, 2024, the Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight of Miss Reed's SUV. Boom. let me see this footnote here. ADA Lally was cognizant of other discoverable materials that the Commonwealth did not disclose before certifying his compliance with his discovery obligations. Notably, when filing the certificate of compliance, he expressly represented that the lone exception of outstanding discoverable material was some evidence related to DNA testing and analysis. On April 23rd, 2024, the Commonwealth produced additional footage for the CPD Sallyport back wall via a share link entitled Additional Sallyport Video Download Link. No flash drive was presented to the defense. Exhibit H, inverted Sallyport video. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached or touched the right rear taillight of Miss Reed's vehicle after it entered the Sallyport. ADA Lally craftily elicited testimony from Sergeant Buchanan that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the CPD on January 29th, 2022, and that, as seen in the video, no law enforcement officer approached the right rear taillight. On cross-examination, however, Sergeant Buchanan's testimony was exposed as profoundly misleading and at best and perjurious at worst. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, critical facts which neither ADA Lally nor Sergeant Buchanan saw fit to inform the court, defense, or jury. In other words, the video made the left side of Miss Reed's SUV appear to be the right. The Commonwealth never filed a supplemental certificate of compliance, and the right appeared to be to the left. Therefore, the video presented to the jury as fair and accurate appeared to show a person, Trooper Proctor, standing near the left rear tail light of the vehicle, when in fact, Trooper Proctor was standing near the right rear tail light of the vehicle. Moreover, the inverted video does not capture the condition of the right rear tail light, and it conceals Trooper Proctor's presence by the right rear tail light. This leads to the inescapable conclusion that ADA Lally questions Sergeant Buchanan's responses, and the deliberate instruction of inaccurate evidence was designed to perpetrate a fraud on the court, the jury, and Ms. Reed with respect to a critical issue in the case. In other words, this was designed to frame Karen Reed. That is, make no mistake, a fucking frame job. In other words, what's up, Tammy Holcomb? Right? I mean, let's just call this what it is, because it's not theory anymore. When you have Hank Brennan lying as much as he has been in all of these pretrial hearings, the fishing expeditions that he's gone on, all these little tactics to try to rob Karen Reed of a defense. When you look at all of these things, and then you look at that Sallyport footage and the issues that have been taking place with this Sallyport footage, it is a fucking frame job. That is a deliberate alteration of evidence. Altercation of evidence or alteration? I don't know. But, I mean, you're deliberately fucking with the evidence. You are. I mean, that's a frame job. When you're deliberately fucking with the evidence, that's a frame job. It's just that simple. It's not even like, and this is just going on and on and on. Like, Bev has to see this. You see what I'm saying? Like, this is why I keep calling her dirty, because nobody of any sound character thinks that what's going on is okay in any fucking way, shape, or form. No decent person. It's crazy. Everything about this case is wrong. Everything about it. And that's just supposed to be just a coincidence. It's all negligence. It's just a bad investigation. And, no, man. It's no coincidence that Michael Morrissey's office was under federal investigation. That's no coincidence either. It's no coincidence that Hank Brennan tried to use this case to try to compel the U.S. attorney to share their witnesses in the investigation. If you remember correctly. Why? For what? What would be the purpose of that? Other than just trying to get ahead of something. Yeah, Brennan is a dirty motherfucker, man. This dude is not. He is not a person of sound character in the slightest bit.
Oh, here we go. Yeah.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
I can't believe Bev is doing this in front of the whole world, right? I mean, you just super chatted 5 pounds. So I'm guessing you're in England. So thank you for that. Yeah. I mean, people from around the world are watching this because it's so fucking unbelievable. Karen Reed is 100% being framed. 100%. Post-trial on October 10th, 2024, the Commonwealth again provided new footage, this time from the CPD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side cameras. This footage shows Higgins arrive in the parking lot of the CPD at 1:26 a.m., enter the building, and speak to some identified individuals on the phone as he is leaving the CPD at 1:34 a.m. Significantly, this specifically requested material and relevant evidence, which establishes that Higgins was on the phone with some identified individual at 1:34 a.m. as he left the CPD shortly after John O'Keefe's death was suppressed until after the trial. Wow. Yeah. Kim K, thank you so much. Do you like my picture? Yeah, that's my face superimposed on Tom Hardy's there from Warrior that I use. And yeah, good stuff. Thank you. Appreciate it. Yeah, so and this was suppressed at the trial. He lied on the stand. On November 8th, 2024, while prepping for Ms. Reed's second trial and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, attorney Elizabeth Little emailed Special District Attorney Hank Brennan, ADA Brennan, again requesting inter alia all raw video footage from the CPD, which shall include, but is not limited to, all cameras capturing the interior of the CPD and the exterior of the CPD, including all parking areas, entrances, and exits and garages between January 29th, 2022 at 12 a.m. and January 29th, 2022 at 11:59 p.m. On November 25th, 2024, ADA Brennan indicated via email that he would request the CPD provide all requested footage. And I wish they wouldn't call him ADA Brennan. Call him Special Prosecutor Brennan. You know what I mean? I feel like just since all this stuff is going on record, you know what I mean? Like this stuff is being forever memorialized. So I say call him Special Prosecutor Brennan. Ultimately, the defense requested access to the CPD DVR system and drives that hold recordings from the security camera system so that defense expert Matthew Erickson could obtain video files and corresponding log files from January 29th, 2022 between 12 a.m. and 11:59 p.m. Upon reaching an agreement with the Commonwealth, Matthew Erickson visited the CPD on the morning of December 12th, 2024 to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means the Commonwealth failed to preserve the specifically requested material and exculpatory footage relevant to Ms. Reed's case via standard forensic protocols, as they were obligated to do pursuant to the February 2nd, 2022 preservation order and October 5th, 2022 order compelling the discovery of all videos and related metadata. On January 28th, 2025, the Commonwealth yet again turned over an additional CPD surveillance footage from January 29, 2022. This time from an exterior camera depicting Miss Reed's SUV being brought into the Sallyport garage. Main driveway, side, exterior, Sallyport, blah, blah, blah. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport garage and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear taillight as it entered the Sallyport garage. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time that the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Sallyport. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial. McCabe is a key Commonwealth witness. Her credibility is critical to the Commonwealth's case. On February 2nd, 2022, mere days after O'Keefe's death, the MSP obtained a forensically imaged McCabe's cell phone. The forensic examination of McCabe's cell phone revealed significant exculpatory evidence supporting Ms. Reed's third-party culpability defense, inter alia, establishing that McCabe Googled Hasselong to die in cold at 2:27 a.m. on January 29, 2022, 3 hours before she supposedly discovered, quote-unquote, Mr. O'Keefe's hypothermic body in the snow on her brother-in-law Brian Albert's front lawn. McCabe then took steps to delete that one search out of more than 4,560 on her phone, along with nearly every communication made on her phone in the hours following O'Keefe's death, only some of which were recoverable from her phone using forensic extraction software. The close and long-standing relationship between the Albert and McCabe families and the law enforcement officers assigned to investigate this case is central to Ms. Reed's third-party culpability defense. CPD Sergeant Lank, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29, 2022. In preparation for trial, the defense uncovered location information on McCabe's cell phone, which proved that she went to first responding officer Sergeant Lank's home on January 30th, 2022, the day after O'Keefe's death. On May 7th, 2024, in accordance with the court order that parties disclose all information to be used for impeachment purposes, Attorney Little emailed ADA Lally and ADA McLaughlin to provide location information from McCabe's cell phone, establishing that she went to Sergeant Lank's house on January 30th, 2022. Unbeknownst to the defense, ADA Lally and ADA McLaughlin shared this impeachment information with Lieutenant Tully. On May 10th, 2024, in a then undocumented meeting, Lieutenant Tully, ADA Lally, ADA McLaughlin, met with Jen McCabe shortly after she was scheduled to testify in the first trial. McCabe's materially inconsistent statement about meeting Sergeant Lank was not memorialized in any report or otherwise disclosed to the defense in advance of McCabe's testimony at trial, in violation of Brady Giglio Rule 14. McCabe testified beginning on May 17th, 2024. During cross-examination on May 21st, 2024, she testified that she received a text from her sister, Nicole Albert, on January 29th, 2022, stating, "We'll get more info tomorrow. Don't want to text about it." To which she responded, "Right." When Ms. McCabe was asked whether anything significant happened the next day, January 30th, 2022, McCabe volunteered the following story. "I went to the O'Keefe's house. On my way home, Carrie Roberts' daughter is good friends with Michael Lenk. So we dropped her off at Michael Lenk's house, and Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asked how the O'Keefes were doing. And, we talked to her." She testified that she was at the house for approximately an hour, that she might have ran and gone into the bathroom. On cross at trial was the first time McCabe mentioned going to Sergeant Lank's home on January 30th, 2022. When pressed further, she admitted that she had discussed this issue at a meeting a couple of weeks prior to the DA's office. She testified that at the meeting at the DA's office, I was asked, "Oh, were you at Michael Lank's on the 30th? She admitted that at first I said, no, I've never been to his house. Then I thought about it and said, oh my gosh, yes, I did go there. And that was the extent of the conversation. She further testified Tully did not ask her any of the follow-up questions about why she went to the personal home of Sergeant Lank the day after O'Keefe's death, and that he did not take any notes. On May 29th, 2024, only after the defense was deprived of the opportunity to effectively cross-examine McCabe and Carrie Roberts during their visit to Sergeant Lank's house, Lieutenant Tully memorialized his meeting with McCabe. Report of Tully's interview with McCabe. Notably, Lieutenant Tully memorialized McCabe's inconsistent claim that she went to Sergeant Lank's home to pick up Carrie Roberts' daughter. Lieutenant Tully's May 29th, 2024 report, which also omitted any reference to McCabe's exculpatory statement in which she denied that she ever went to Sergeant Lank's house, was not disclosed to the defense until June 4th, 2024. Wow. Yeah, trial's already over. Commonwealth engaged numerous Rule 14 discovery violations and constitutional violations under Brady versus Maryland and its progeny. Ms. Reed's constitutional rights to effective assistance of counsel and to due process under the law is guaranteed by Article 12 of the Massachusetts Declaration of Rights, and the 6th and 14th Amendments to the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial. Declaration of Right of Massachusetts Constitution, also Commonwealth, defendants have an unquestioned right under the 6th Amendment and Article 12 of the Massachusetts Declaration of Rights to obtain relevant evidence that bears on the question of his guilt or innocence, or which otherwise helps his defense. Pursuant to Brady versus Maryland and its progeny, defense counsel is entitled, as matter of due process, to all evidence that is favorable to the accused and material either to guilt or to punishment, including the impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and his credibility to the test. United States versus Bagley, 1985. 1985? Brady disclosure also extends to disclosure of information useful to the defense to attack the reliability of the police investigation and the police methods employed in assembling the case. Kyle versus Whitley, 1995. Doc, you don't just walk into a store and buy plutonium. Did you rip that off? In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts rules of criminal procedure clearly state that the Commonwealth must provide certain mandatory and automatic discovery of evidence within the possession, custody, or control of the Commonwealth to the defense in order to meet its mandatory discovery obligations. As amended, information subject to such mandatory discovery includes blah, 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 blah. Do you guys want me to read all this like really technical legal mumbo jumbo? Because let's see. All right, no, I'm going to read it. The rules also state the defendant may move for discovery of other material and relevant evidence not required by subdivision. Here on February 2nd, 2022, the Commonwealth was ordered to preserve all physical evidence, including video surveillance footage in Stoughton District Court. Subsequently, on October 5th, 2022, this court ordered the Commonwealth to produce all videos in connection with the case and associated metadata. Notably, the prosecutorial duty to produce evidence covered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, including police. The prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case, and either regularly report to the prosecutor's office or have done so in the case. Commonwealth versus Sleeper, quoting Commonwealth, blah, 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 blah. Prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation and presentation of the case. See also Commonwealth, blah, 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 blah. Check out this footnote here. See reporter's notes. The provision requires the prosecution to provide automatic discovery of any facts of any exculpatory nature. It derives from the constitutional requirement established in Brady versus Maryland that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. The duty is also an ethical one imposed on the prosecution by blah, 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 internal citations and quotations omitted. As set forth herein, the Commonwealth has repeatedly violated its discovery obligations under Brady versus Maryland and its progeny in Rule 14. The Commonwealth's production of the April 23rd, 2024 inverted video from the CPD Sallyport garage violated Rule 14 in the court's October 5th, 2022 order compelling the production of the video evidence. First, the Commonwealth violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence by withholding the inverted video from the Canton Sallyport until after the start of trial and after the Commonwealth had already filed its certificate of compliance on April 23rd, 2024. Exactly. So why the fuck is Bev letting this just shit happen? At best, the inverted video had been in the Commonwealth's constructive possession since January 29th, 2022, the night in question. At worst, this video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the right rear taillight of the defendant's SUV upon its arrival in the CPD Sallyport. Either way, the Commonwealth's production of the inverted video in the middle of the trial and after it had filed its certificate of compliance violated Rule 14. After trial in this matter on October 10th, 2024, Commonwealth produced previously withheld video surveillance from the CPD's church-side exterior and rear lock cameras, which show inter alia Higgins arrive in the parking of the CPD at 1:26 a.m., enter the CPD and speak to some identified individuals. I've already read this. Yeah, they left that shit out. So I mean, look at all these violations. Last month on January 28th, 2025, the Commonwealth provided additional CPD of surveillance footage from January 29th, 2022. This time from an exterior camera depicting Miss Reed's SUV as it was driven into the CPD Sallyport garage. The camera angle should have had a clear and unobstructed view of Miss Reed's taillight as it was driven into the Canton Sallyport garage. However, yet again, the footage is too blurry and grainy to make out the condition of the taillight. Notwithstanding the fact the footage is exculpatory and shows an individual approach the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport and then exit shortly thereafter. The video surveillance footage has been in the Commonwealth's possession since January 29, 2022, and was withheld the defense for 3 years. Now, how much do you want to bet? Because here's where my money's on. How much do you want to bet that what happened there, where that part was blurred out, and then the individual approached the right rear taillight, the passenger side taillight of Karen Reed's SUV, that someone smashed the fucking taillight and planted the pieces and took it over to the 34 Fairview to plant the pieces? That's exactly what I think happened. Smashed the taillight, left with the pieces. What's up, Mizzy? Good to see you. Now, I'm still like, I don't know if I want to read all this, man. Yeah, I do want to read this part. To be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case. The footage that has been produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability of the CPD's video surveillance footage obtained from the Sallyport on January 29th, 2022, because without metadata, you can't forensically examine the footage. It can't be verified. Jesus, I can't believe that, like, Bev knows this. She knows this. This isn't negligence. She knows this. The case should be dismissed just based on that. The Commonwealth has produced numerous video files without any way to verify their authenticity. These video files include a file capturing the interior of the Sallyport garage with a 42-minute gap missing at the precise time that the feed would have shown an unobstructed view of the right rear taillight of Miss Reed's 6,000-pound SUV as it entered the CPD Sallyport garage, in spite of the fact that the Commonwealth claims the video surveillance feed is motion activated. The mid-trial production of the inverted video produced by the CPD in an attempt to save face for the gap in the footage, which improperly depicts right as left and left as right and falsely suggests that no one from law enforcement approached the right rear taillight, and a blurred out video that obstructs what would otherwise be another clear view of the right rear taillight of the SUV as it entered the Sallyport garage on January 29, 2022. It is not a coincidence that none of the many cameras on the CPD Sallyport garage captured the condition of the right rear taillight upon its arrival at the CPD, and before the first pieces of taillight lens material were recovered by law enforcement at 34 Fairview Road. The fact that the Commonwealth and its agent, the CPD, failed to preserve the footage in a forensically sound way and allowed critical evidence to be destroyed is not a coincidence and goes to the heart of Miss Reed's defense and the credibility of some of the Commonwealth's most central witnesses. Proof that it is a frame job. Even if ADA Lally was not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. So would the judge. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. See reporter's notes, blah, 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 blah. Evidence in possession of the police is Brady material, even if the prosecutor is unaware of it. So the prosecutor has a constitutional duty of inquiry. Following the February 2nd, 2022 preservation order, ADA Lally should have, and a diligent prosecutor would have, promptly notified CPD to preserve any existing footage and inquired about whether the DVR system overwrites or deletes old data. The certificate of compliance ADA Lally signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. ADA Lally did anything but, and the Commonwealth is responsible for resulting loss of this critical exculpatory evidence, which cannot be cured short of a dismissal of this case. The Commonwealth withheld the May 10th, 2024 exculpatory statement of McCabe, in which she denied traveling to the personal residence of, okay, yeah, we already read that. Let's see. Dismissal is appropriate as a remedial sanction as a way to cure any prejudice caused by the violation of a discovery obligation and ensure a fair trial. Dilworth, 494, Mass, blah, 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 blah. Commonwealth versus Carney. Not that Carney, Art Carney kind of Carney. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to a defendant that represents or prevents the possibility of a fair trial. The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the rights of defendants against the necessity of preserving society's interest in the administration of justice. Do I want to read all this shit? Given the extreme governmental misconduct in this case and the irreparable nature of the harm to Miss Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the Supreme Judicial Court. Now, we all know Bev's not going to dismiss this. Here, Ms. Reed has been irreparably prejudiced by the Commonwealth's discovery violations in this case. That is a fact. The first trial resulted in a hung jury precisely because this was a close case. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Ms. Reed was constitutionally and statutorily entitled, the result of the trial may very well have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defense in a concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witness in this case, including Sergeant McCabe, and Higgins. Moreover, the Commonwealth continued piecemeal production of exculpatory video footage, which has by definition been in the Commonwealth's possession since January 29th, 2022, is a flagrant violation of the Commonwealth's constitutional and statutory obligations under Rule 14. It is well established that suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either guilt or punishment irrespective of the good faith and bad faith of the prosecution. Okay. All right. Now let's see this. And then there's, yeah. Taking into account the blah, 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 cracked, not cheddar, derived, conflicted. Okay, yeah, and it's talking about Sergeant Barrow's testimony, which is very clear. The misconduct of the Commonwealth in this case was egregious, deliberate, and intentional. And the petty paralegal just gifted 10 memberships, y'all. Holy cow. Holy, oh my. Thank you, petty paralegal. Appreciate you. Yeah, I mean, it repeats a lot of shit here. So, because I'm trying to manage time as well. I've been live for an hour and a half. Because there's other stuff I want to go over. Like, I was sent a whole bunch of stuff, and thank you to the person who sent it again. Oh, is this about the juror? I want to read about the juror. Okay. This is more about the discovery. Additionally, dismissal in this case is also required a remedy of violation of Ms. Reed's Sixth Amendment right to an impartial jury. Notably, a jury may never be dismissed because of their views on the case or for reasons having to do with the relationships with other jurors. Instead, jurors may not only be dismissed for reasons personal to the juror that have nothing to do with those views on the case or relationships with other jurors. Oh man, I wish I could read that redacted part. Dismissing a juror because of their views violates a defendant's Sixth Amendment right to an impartial jury. Yeah, all that stuff. Jury tampering such as this is a presumptively prejudicial and triggers a burden on the government to prove that the tampering was harmless to the defendant. The Commonwealth cannot do so here. As per Massachusetts law, courts do not have the discretion to dismiss jurors when doing so would be in the best interest of justice. Judges can do this at any time during the trial process. Although the procedural burden and standard vary at various stages, post-impanelment, but pre-deliberation, if a judge is altered to potential misconduct of or affecting jurors, the judge first determines whether the material raises a serious question of possible prejudice. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Okay, that wasn't done. Ultimately, Ms. Reed's Sixth Amendment right to an impartial jury entitles her to certain procedural protections when it comes to dismissal of jurors. These procedural protections were not provided here. These constitutional violations, along with the egregious discovery violations discussed above, demonstrate the inherent unfairness of the proceedings against Ms. Reed and warrant dismissal of this case against her. In conclusion, for the above reasons, Ms. Reed respectfully requests that the Honorable Court grant defendant's motion to dismiss for extraordinary governmental misconduct with prejudice, although dismissal is required and appropriate under these circumstances. In the alternative, the defense seeks and is entitled to an evidentiary hearing on these issues attendant to the Brady violations and jury interference. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, wow, Trooper Proctor, Sergeant Buchanan, Colleen Crawford, and members of the CPD, and Lieutenant Fanning. I love that shit. What? So yeah, I love that shit. So I don't think she's going to grant either. she's not going to grant the motion, and she's not going to allow the evidentiary hearing. That's not going to happen. But how dope would it be to put those fuckers in the hot seat and get them to testify? I want to see Brennan testify. I want to see Lally testify. I want to see Elizabeth Little fucking grill those motherfuckers. That's wild, man. This is just wild. And then there was an opposition motion, which I'm going to go over in just a second. Okay, here we go. Got it right here, y'all. It's only 15 pages, so we're going to go over it. Yo, thanks for being here, guys. You guys are dope, man. Appreciate it. All right, let's get into it. Now comes the Commonwealth in the above captioned matter and submits the following in opposition to the defendant's renewed claims that her indictment should be dismissed because of egregious governmental misconduct. The Commonwealth disputes any ethical violations of misconduct, let alone misconduct that taints the legal system or infringes upon the defendant's right to a fair trial. The defendant's motion should be denied. Dismissal as a sanction is a very strong medicine and should be prescribed only when the government misconduct is so intentional and so egregious and appropriate only upon a showing of irredeemable harm to the defendant's opportunity to obtain a fair trial. To the extent of the defendant has suggested that egregious circumstances might warrant dismissal, the Supreme Judicial Court has noted that we have never dismissed charges in such circumstances in the absence of prejudice. Judicial responses should be limited to truly remedial, Your Honor, and not punitive measures. The Commonwealth does not dispute its prosecutorial obligations and constitutional duty to disclose in a timely manner material exculpatory evidence over which it has possession, custody, or control. Nor does the Commonwealth dispute its broad obligations to inquire and disclose any facts that would tend to exculpate the defendant or diminish her culpability in all statements and witnesses. The Brady obligation comprehends evidence which provides some significant aid to the defendant's case. However, to prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must first prove that the evidence was in fact exculpatory. Commonwealth versus Healy. Exculpatory evidence includes all evidence that tends to negate the guilt of the defendant or provides some significant aid to the defendant's case. And while rightfully broad, the conception of exculpatory evidence is not boundless. In 2022, the Commonwealth provided the defense with approximately 90 crime scene service photographs depicting the condition of the defendant's vehicle in the Canton Police Department Sallyport. Further provided to the defense was ring surveillance footage of the defendant's broken rear taillight at approximately 5 a.m. Statements of the witnesses who observed the defendant's broken taillight at 5:30, Canton Police cruiser video depicting the defendant's broken taillight at approximately 8 a.m., observations of damaged taillight by the Dayton police, and automated vehicle location data from the troopers' cruisers who were assigned to the CERT team, evidencing that the CERT team was on Fairview Road versus the defendant's vehicle arrived at the Canton Police Station. Lieutenant Kevin O'Hara of the Massachusetts State Police CERT team testified at trial, and his automated vehicle locator records confirmed his arrival at 34 Fairview Road on January 29, 2022 at 4:56 p.m. Lieutenant O'Hara additionally testified that his arrival was preceded by one other trooper from his unit, Trooper Jason Butelselli, at 4:54 p.m. The defendant's vehicle arrived on the back of the flatbed tow truck at the Canton Police Station at 5:30 p.m. The defendant has also repeatedly represented in the media and postured at trial that her taillight was broken at 5 a.m. by striking the victim's parked vehicle in the driveway of the victim's home. She said she cracked it, you dumb shit. Like, dude, this guy is fucking ridiculous, dude. This guy is fucking ridiculous. Like, he just does this all the time. He just lies. And like, if he just says the shit out loud or puts it on paper, like, it just becomes true. That's basically the dynamic between Brennan and Bev. The dynamic between Brennan and Bev is Brennan will make up absolute and utter bullshit, and Bev will go, okay, that is what has been happening. No, Olivia, I'm back on Twitter. I got my account back. I got it restored. You missed the beginning of the stream. I'm streaming on Twitter right now. Yeah, this is just fucking ridiculous, bro. Okay, cool, Olivia. Right on. Yeah, man, I just kept appealing it. That's all I did. I just kept fucking appealing it. And then I stopped giving a fuck what I said in them. And then somebody, I believe it was Elon, bro. I believe it. Elon was like, all right, dude, you're cool, bro. Go ahead. In June of 2023. What? Hold on. See what we got here. Am I reading this right? Okay. Olivia explains it. Fantastic. Okay. Here we go. So Olivia posts, the Commonwealth's got some splaining to do because according to their own files, they had Sallyport footage from the Canton PD on June 2nd, 2023, and potentially even earlier, as that's just the date modified column saved in the prosecution's own CPD Sallyport videos folder on their computer used to pull up exhibits on the TV screen at trial. Not only does the prosecution have 10 total CPD Sallyport video files in its possession at the time, but several of them are dated June 2023. For reference, the Commonwealth only produced 2 total Sallyport videos to the defense before the end of the first trial. These included the one video that's practically entirely blackened out of the inverted video. Starting as early as June 2nd, 2023, there are 5 total files last modified on this date, all with varying times. Additionally, there is a file each from June 7th, 2023 and June 30th, 2023. Then in 2024, there are 2 Sallyport video files dated March 21st, 2024, and 1 file dated April 16th, 2024. The first date that the Commonwealth ever produced any Canton PD or Sallyport footage was in its notice of discovery on April 4th, 2024. Isn't it just amazing what metadata can tell you? These file metadata seem to unravel every bogus story and excuse the Commonwealth's provided to try to explain away why it's hidden and withheld Brady evidence, Rule 14 discovery, and court-ordered evidence for nearly 2.5 to 3 years. No wonder Judge Beverly Cadoni didn't want the defense getting their hands on the metadata. Shout out to for first catching this bombshell. Give them a follow. Who's this? Look the other way. All right, they're following me. I'm gonna follow them back. Okay, look the other way. I see you. I look the other way and I see you. Beautiful. Fantastic. And hold on, let me show this real quick. Y'all got to see this shit right here. There we go. Boom. So look, here are the dates right here. Interior Sallyport back wall, 4/16/2024. But look down here, June 2nd, 2023, O'Keefe Sallyport. O'Keefe Sallyport. Literally, it says O'Keefe, like it's that case. June 2nd, 2023, O'Keefe Sallyport. June 2nd, 2023, 1:47 p.m. O'Keefe Sallyport, June 2nd, 2023. Dude, there's like 1, 2, 3, 4, 5. There's 5, 6 June 2nd Sallyport videos. June 2nd Sallyport videos. 2023. So before the trial. And they showed the shit on in the trial. Like this, somebody caught this shit and fucking took a screenshot of it when they were showing this, and this fucking proves that they've had these things since June of 2023, early June of 2023. June 2nd, to be exact, are the dates. What? Bro, Olivia Nile is just absolutely a gem. She is a treasure. Absolutely. Absolutely. Okay. Yo, man. I got so many steps in today and I worked out at the gym and like I hadn't eaten anything yesterday. And then so today what I made was like I made like 2 pieces of chicken breast that I cooked in just a little bit of like olive oil and avocado oil and some whole grain rice and a couple of eggs, also lightly fried in like over medium, cooked in the same oil. And it was delicious. And it was a lot of food. I even threw in like I had like 3 leftover pieces, like sausage links. I made those and threw them in there. And then and right now, like I'm hungry as fuck. Oh God, like I'm trying to like burn fat, but it's just so hard to do that because like I just get so hungry. It's so crazy because it was a lot of food. It was like 2 pieces of chicken breast and like this whole thing of like, of rice, eggs, sausage. Insane. Well, I think you are getting hung up on these detail like dates. Nothing to see here. Look the other way. Keep up the great works. Thanks, Jason. No, but that's all Olivia, man. Olivia and that person that she credited there looked the other way on Twitter. Pretty awesome. Let me do this real quick. I'm gonna drop the link to Look the Other Way's Twitter in the chat. Go give them a follow. Go give them a follow. Oh man. You know what I didn't do? Hold on. 1 second. Yeah, man. All right, there we go. The Karen Reed Defense Fund link is now pinned to the top of the chat. Every little bit helps. And man, again, another big shout out to Mazza Media for that fundraiser yesterday, man. He raised over $4,000, dude. That was amazing. Let's see what I'm going to do here. What am I going to do here? Okay, let me do this. All right, give me just 1 second here. All right. So I'm gonna go ahead and open the phone lines here, folks. So feel free to call in. Talk to El Jefe. Yeah, I mean, I didn't want to read that whole motion. I was over it. Like, I get it. You're on. Who am I speaking with?
Oh, sweetheart, how are you tonight?
I'm good, sweetheart. Who's this?
Not that Dina.
Not that Dina. Of course it's not that Dina. Fuck.
Well, I didn't have time to play around because I got other shit to do, so I wanted to touch base before I got into the rest of my night. I'm just gonna ask you a question. So, and it has nothing to do with the case. Oh, shocking. So you're like working your diet. Me and my husband cut out carbs, not completely. We just took out like pasta, rice, and bread for inflammation purposes.
Do you exercise at all?
Oh yeah, I do physical therapy, and because I have like no cartilage in my knee, and I walk daily.
Okay.
Every day.
Yeah, walking is good. As long as you're walking, at least. And so yeah, carbs, you definitely want to, if you're trying to lose weight, it's good to cut down on those. But what you want to stay away from is alcohol, sugar, and seed oils. You want to stay away from these
Okay, so I only use olive oil and like grass-fed butter in my cooking.
Yeah.
But
butter's
I drink
okay,
wine.
but a little bit. And you drink wine, I mean, there's tons of calories in that shit. Like and alcohol, it's just gonna retain your water, and it's it's no good.
Yeah, but I fucking quit out beer. That was huge. That was a big deal.
You want to lose weight, you
want
to lose weight, you gotta quit drinking so much. It's that simple.
Oh, okay.
I mean,
well,
I don't know what else to tell you. Like you asked me a question, I answered it. That's it. Like,
well, my big question
thank you
is
so much, Diane. I appreciate it. Go ahead. What's
my big question is, how do you feel about rice?
Rice?
Yeah, because we've cut that out too.
Well,
and it's like really screwing us up.
I eat rice now because it has like good carbs. Like I'll eat jasmine rice or like whole grain rice like I ate today. And I pour like olive oil and vinegar on it. And it's really delicious that way. It's just the way it, like in a Dominican household, there was olive oil and vinegar on the table, to put on your white rice. I always did that.
Same with Italian. Same with Italian.
So I've been eating that stuff, but the thing is it's because of the carbs that I am eating it, because it's just the right amount of carbs. So because I lift and I want muscle gain, so I don't want, you know what I mean? If I wasn't lifting and I was just trying to lose weight, I wouldn't eat the rice. You know what I mean?
I'm not looking to, I need to lose weight. Of course, everybody does. I'm more looking for inflammation purposes, because we're older and we're like, got the heating pad on 24 hours a day. Because something hurts.
I would talk to a dietitian. I'm just telling you what I do.
Yeah, fuck them people. They're just, it's like having an Italian telling me to stop eating pasta. I did, but it ain't because of him, because fuck him, don't be Italian and tell me to stop eating pasta. Go shit in your hat. I'm going to stop eating pasta because I know it's the right thing to do. All right. So anyways, but all right.
I mean, you just got to remember, it's not how much you eat, it's what you eat, So
yeah,
if you're just if you get some exercise, you get a certain amount of steps a day and you burn a certain amount of calories per day, it should be enough to just stay away from alcohol, sugar, and seed oils.
Okay. The alcohol's the only problem.
I mean, it depends
Okay,
on
so-
your genetics too. I mean, I don't know, but like I said,
No, my husband.
I talked
My
to a
husband's like
dietitian, really.
he's like a rod. He's like a rod. He eats like 10 times more than me, gains 0 weight, and is hardly works out except for golf. And he looks like a fucking Adonis. I am a lump, and I'm a good lump. I'm not like a shaky lump, but I'm a good lump.
I feel you.
But he's, you know what I'm saying?
Yeah.
He just
And
just
he's
doesn't
happy, right?
gain weight ever.
He's happy, right? You guys are.
Oh.
Yeah, man. Like.
Yeah, we're good.
Like, listen,
we're good all day, every day.
I work out to feel good. I work out literally to manage my depression and anxiety. I have severe depression and anxiety. And I because if I take medication for it, it fucking shuts me down and I can't be the vibrant person that you guys love so much here. So I can't.
And we do.
So I exercise a lot to manage that. And it helps.
That's
what the best thing I've ever done.
That's what my son does. My son works out every single day. He's the one. He pushes me on hikes and everything like that. We go all through all the different woods in Massachusetts. It's fantastic. I wish he didn't move to Florida because now it sucks. But the only other thing I want to say is there's so much content. We went from like 0 content to like, who do I listen to? And it's kind of rough. I got to promise you. I'm always going to push you to the front. And even if I get like exhausted, I'll throw you on my iPhone. I don't have an iPhone, my Android, and throw you over to the side and just let it run because I want you to have that algorithm. And
I'm talking to you on a fucking MacBook. I'm gonna hang up on you because I don't want to get fucking Android cooties. I'm just kidding.
All right.
No. I'm just kidding. I'm kidding.
You don't have to worry about my cooties. You go on and you get other calls, but I'm just saying there's so much content right now. It's annoying because I love all you people and I want to honor all you people and I want to hear all your different opinions, but there ain't enough fucking hours in the day because some of you people like Runkle go on for like 5 fucking hours at a time. And it's bullshit.
Runkle,
I love
man,
them.
Runkle is dope though, man. And he's
so funny.
Yeah, Runkle's dope, dude.
And he does like other stuff. He's like guns and hot sauce.
I love Runks.
He's very liberal, very progressive, but I can that doesn't annoy me enough to not watch him. Anyways, all right. Have a good night.
You too, not that
and
Dana.
Oh, sweetheart. I love you. Good night, sweetheart.
Good night.
Bye.
Fantastic. We love not that Dana.
Call from.
You're on. Who am I speaking with?
Hi, well, it's Liz. Liz 8888.
Oh, what's up, Liz?
I said I wasn't going to call for a whole month.
We love Liz.
I know, but I said I wouldn't call for a whole. Yeah, because some people don't really like me. But I even wrote down my question, and SD told me that I can call. She said, "Liz, you better call." So I said, "Okay." So I'm going to get right down to business. Why isn't anybody helping us? Like,
why isn't anybody what?
Helping us, like the feds or anything. Why is this being allowed to happen?
The problem with that is, it's a two-sided coin because that's what makes the United States the United States. You know what I mean? Like federal intervention doesn't happen unless there are federal crimes being committed.
Right, but
so like the state the way this country works is the state it governs itself.
Right. Well, it should, but why isn't anyone then in the state level? It's obvious what Bev is doing.
Because at the state level, it's corrupt as fuck.
Right.
So it's like.
You would think this would happen in some back-ass woods country, really, with the sheriff, the good old boys and stuff. Not in,
this is absolute good old boy bullshit going on in Massachusetts.
But people should be outraged. I'm pissed. When I know everyone in the movement, but where are the other people that are pissed? Like, it pisses me off. Like, I don't know. It's so weird. Like, Everyone should be talking about this.
Yeah, it's bizarre.
Yeah, so I
It's bizarre.
just maybe, yeah, but you know what? It's another thing is it's not on the news around here. Only Ted Daniels will talk about it, and even those interviews he did, they weren't on local news. They were only on YouTube. So it's kind of a limited audience as far as what, like the people like my dad and stuff are getting around here. They just talk about when she goes to court. And like the first thing a lot of people heard was they had footage of her hitting him. So it made people be like, oh, that's too bad, and then they didn't all come out and say, oh, we're wrong. We're so wrong. Nobody ever, it was crickets. Nothing was said. It's just, it's effed up. But that's I think that's all I had. Oh, I wonder if Howie Carr, right? I listen to him too, and I have for a long time. He's like friends with Trump. He goes to Mar-a-Lago. Like, why wouldn't he say something to him? Like,
I didn't know that Howie Carr and Trump were homies, but now
they're homies. Oh yeah.
I guarantee you that the subject has come up if they're talking.
They talk it. Howie goes there. He stays in Palm Beach.
Howie would not have the opinions that he has as strong as they are. He wouldn't have Turtle Boy on there so regularly.
Right. That's what I'm hoping.
Howie's invested in this case, and if he's got the luxury of bending the ear of President Trump.
Oh, yes, he does. He really does. And he goes to Mar-a-Lago
I'm sure
once a week.
Doing it or is going to do it, but I can't expect him to do it. I'm just saying.
Right.
I'm saying I would assume that he would because of how invested
he could. Yeah, I think.
But if there was no reason why
he
didn't feel comfortable doing so, I wouldn't blame him either. You know what I mean?
Right. I don't know. I think he's the type that would say it. I was just thinking about that. Like, sometimes you just lay in bed and think about this case. It's so crazy. And I was thinking about that, like saying, God, Howie's the type that would bend his ear. And I know he goes there once or twice a week to eat, and Trump was on his show a good amount of time, before pre-election. So, but also avocado oil. I wrote that down too. How is that?
What?
Avocado oil.
It's fine. That? It's just good. It's a good oil. Like if you're trying to lose weight, a fun fact about olive oil, like as long as you don't overdo it, but a fun fact about olive oil is like it actually it burns fat. So it's a good fat that burns bad fat. And and olive oil actually targets stomach fat, as I understand it. So it's always good to cook a little, like if you're eating a salad, pour just a little bit of olive oil on your salad. And
I cook with olive oil and we use it quite often.
Yeah.
Cool. All right, I'm going to get off and let everyone else talk. And it was good talking to you. And
always, Liz.
Thank you for everything you're doing for us.
Oh, thank you.
You have so many people. All right, you have a good one, sweetheart.
You
Bye-bye.
too, Liz.
Bye-bye.
Bye. She's just the sweetest, man. Jeff David, I'm 61, just started carnivore diet to lose weight and bring blood sugar down. I do cardio at the gym. Any other advice? Can I look like you by 62? Yeah. Yeah. I mean, I don't know how much weight you got to lose, but yeah, you totally can. It just depends on how disciplined you are. How much time you got? Are you the type to make excuses? Lynn Britton, member for 3 months. Thank you so much. Don't bad talk Runkle Bailey or Ruben. Nobody's bad talking Runkle. Nobody's bad talking Runks. We love him here. I don't know if he's conservative or liberal. I don't give a shit. I like what he says about the case.
Call from
Lee.
You're on. Who am I speaking with?
Lee.
Lee? What's up, Lee?
Hey, what's up, man? How you doing?
I'm doing fantastic, my friend. How's your Friday evening?
I just got a couple. Right. I just got a couple questions. Why? What else was I say? Do you think that someone can? Do you think that the attorneys, when they call ARCA guys, can they say, has any government agency ever hired you?
Yeah, that's a good question. The thing is, and I'm going to answer that as best as I can without being an attorney.
Right. I know you're not a lawyer, but
right. The answer is no. Lothario is saying no, but I'm going to say that's because Judge Bev had already put in an order saying that it could not be brought up. So that would have been the defense providing a window for them to say that the federal investigate that the feds hired them. So she said if it happens naturally and the door is open, then you can talk about it. And the door opened a couple times and nobody, but whatever. But yeah, that was the stipulation at the time. So that's why they could not have asked that question that way, I don't think.
And for the supporters, when people are out there protesting or whatever, they need to protest directly at the judge.
At the what?
Because by now everybody knows she's corrupt.
At the who?
At the judge. When people are protesting, when they say free Karen Reed, they shouldn't even say free Karen Reed no more. They should just protest the judge and say she's corrupt. She's corrupt. Every day.
Well, I mean, that's the thing is everybody kind of brings their own flavor to the protesting. So, you know, there are people who have shirts that say free Karen Reed, and then they have shirts that have Bev on them, and they have signs that have Bev on them, and they have signs that have, you know, Karen Reed, and it just, you know, there's a bunch of different stuff. You know, somebody even has my super chat image holding out there.
She is the main reason why this trial is still going. She is the reason.
Yeah. Oh, totally. Yeah. I mean, she's just letting things happen. And she gets to claim negligence. She gets to claim like, oh, well, that was just good lawyering on the prosecution's part. He convinced me. No, like he's blatantly lying, and the defense is proving it, and you're just ignoring what the defense is proving.
Right, and he gets up there and he acts like he didn't do anything. I'm just like, I'm looking at this just in amazement, like, I can't believe what I'm seeing.
Right.
You know, it's just like no one's watching. You know, I just don't believe it. But let's add another question. Do you if they get their motion denied to dismiss,
it will.
Can they send that to the Supreme Court?
Can they appeal it? That's a good question. That's a question. That's a question for Lothario. I know she's listening, so but I don't. I honestly don't know. I don't know when you can appeal it. I'm pretty sure you can appeal it, but I mean, the thing is I mean, Bev is just like dead set on this trial starting on April 1st.
Somebody needs
a
to
month
get up
away.
in court. They need to get somebody to get up in court and just start calling her corrupt and just risk it all.
Right.
They need somebody to just stand up in court while the trial is going, or whatever the motion. When the motions, whatever before trial, just like you're corrupt. We know you're corrupt in court and just risk it all.
Yeah, but that's not how you get things done. That's how it's done on TV, not in real life, man.
At this point, you have no other choice because.
No, that's not how it works. Lothario says to repeat your question, and I think the question is, if Judge Bev denies, Lothario, this is for you. If Judge Bev denies the motion to dismiss, can the defense appeal the decision?
Right, to the Supreme Court, though, not back to Bev.
And yeah, I noticed that too, Olivia, but I couldn't spell out the strategy. I'm sure you could. The defense was very strategic with this motion filing. If Bev denies them an evidentiary hearing, then she's essentially conceding that everything they stated is true. Good point. Thank you so much. Jerry Gray, thank you, buddy. Why the hell is there no mention in the motion that the CPD were conflicted out? The biggest corruption allegation is inside the Sallyport. That alone is dismissal in the real world. It absolutely is. You're absolutely right. Lothario, to answer your question, Lee, if she denies the MTD, defense can appeal it after a conviction and only to the SJC. to the Supreme
Okay, I
Justice
got
Court.
you. Okay. Well, yeah, that's all I had. Like I said,
Cool,
somebody,
man.
and I feel like one of the lawyers is going to like snap one day and can't hold themselves back.
I don't think so,
gonna
man.
come.
They're professionals. They've been doing this a long time. You know what I mean? I'm pretty sure that they're going to hold their shit together.
Come.
I couldn't do it.
No,
Like, I feel you. I know exactly what you're saying, and I can see how one would believe that. It's just that these lawyers are professionals. Now, me personally, I've stated this many times. There's no fucking way that I could be, because people will be like, sometimes I'll get on fire here and start making a whole lot of sense sometimes, and then people will be like, Clara should be on Kara Reed's defense team, and then I'm like, you don't want me on there on Kara Reed's defense team, and then it's because I would lose my shit. I would lose my shit. I would absolutely like be like, what in the fuck, lady? What in the fuck, lady? Like, that's what I would say to Judge Bev. What in the fuck, lady?
I never seen people want to see a lady be free that's accused of killing a cop. Never in my life like that. So
I've never seen a case like this ever. I've never seen a judge put up with so much fuckery. Never seen it in my life.
Yep, you're right. So have a nice night, man. That's all.
You too. Thanks, Lee. Appreciate you, buddy.
Thanks. Yep.
He was cool, man. He had some good questions. He was funny though, man. He was like, somebody just needs to lose their shit. It's so funny, dude. I'm out of order. You're out of order. This whole. What's up, buddy? What do you want? I'm not really excited, bro.
Call from.
You're on. Who am I speaking with?
Hi, Will. It's Amy.
Hi, Amy.
How are you?
I'm great. How are you?
I'm good. I just want to touch on the last call. He's like, you both have said like you've never seen a judge put up with so much fuckery.
Mm-hmm.
There's a reason, because no judge has ever done that, right? Like no judge in history has ever allowed that much shit to just go by. So like clearly, I don't know.
I know I've never seen it. I've watched.
No,
I've followed and covered a lot of trials, and I have never ever seen that. I've never seen anything like this. Nothing like this.
She's invested on like listen, I'm not going to sit here and say, do I think there's major corruption? 100%. Do I think she's I think there's a fucking reason. Like, why else wouldn't you just be following the law? Like, you're a judge. Like, what's going on is egregious on every judicial level there ever was.
It is.
It's insane how many things that she has just been like, nope. Like, what? Like, you're a judge. Like, this is the law. You're there for that fucking reason. So she has an interest. Whatever that interest is, we may never know, but I'm telling you, there's a fucking interest.
It's got to be. Doesn't make sense.
Why else would you commit this hard to looking past the actual letter of the law, which is like,
right,
just straight fairness?
Why would you so publicly and for so long consistently make decisions counter to the interest of justice?
I mean, I watch too much, like, FBI and stupid TV shows, but I'm going to say this. Someone has something over her head. Who else would commit to just egregious, like, the shit that is going on as far as, like, the prosecution not turning over anything, and then them trying to come now 3 years in and say that the defense didn't turn over something, and then try to lie that it was the feds, and like try to do all this fuckery, right? When in all reality, you guys have been doing the fuckery since the beginning with your inverted videos and your fucking taillight sprinkle, and like you have more sprinkles of taillight than people do in an ice cream shop. Like, I'm over it. Like, it is
sprinkles of taillight.
Fucking insanity. Like, the judge, there is something going on that, like, we will probably never know, but I'm telling you, there is a motherfucking reason that she's just allowing all this craziness, because no judge I have ever seen in history
has not at least once been like, that's a little too far. Like, you know what I mean? Like everything that the Commonwealth does.
Thank you,
it's like,
Diane
okay.
G.
Sorry, people super chatting you. I'll let you go.
Well, no, Diane G gifted 10 memberships, man. Thank you.
Oh my God, I love that.
Yeah, it's awesome.
Your fucking listeners are the best. I love the chat. I love the callers. I haven't called in a while, but I was like, I've been missing. I like literally have been listening to you religiously. I love it. Like all the other callers said there was too much to watch. I'm loving it. Like, please don't stop. Like, I drive around all day, so I'm like, and it's great. Like I can catch up on all of you and like any
it
point.
needs
It's
more
awesome.
people, dude. Like it needs more people, you know? Like
I agree. Well, I live in Fort Myers, and I can tell you this. There was I think you saw it. There was a woman at the Red Sox game. Like we have mini Fenway down here. And there was a woman sitting behind the dugout, and she was on like, you got Boston's like, you're in Tennessee, but Boston's national news, like Boston's news. But it was on the news down here too. Like the local, like they only did like a minute or two on it, but they explained like what was going on, like bare minimum. There was no like digging deep into it, but it was like, you know, it was cool to see because it's never been reported on news down here. So I was like, go Karen, like let's get it. I don't care how many news places you're on, you know? She needs all the help she can get, that poor girl.
yeah.
Well, listen, I won't keep you. I just hope you have a wonderful weekend, and thanks for all your content. You're the best.
Oh, thanks, Amy. I appreciate you.
All right, have a nice night. Take care.
You too. Bye-bye.
Bye. Bye.
Hell yeah, dude. Y'all are some dope callers, man. Thank you guys for being so awesome. You can't handle this. Dude, I'm not giving my dog weed gummies, bro. Okay. I was going to take, there we go.
Call from.
You're on. Who am I speaking with?
Patrick.
What's up, Patrick?
Hey, quick thing. Have you seen or have you gone over the response to the motion to dismiss at all?
Yeah, I went over a little bit of it today.
Okay, I was just.
I still have.
I didn't mean to.
I still have it pulled up. Is there anything you wanted to reference in particular?
Well, just I mean the whole thing, but there's one thing that I see people gloss over. So their big thing is that the Canton Police Department wasn't a crime scene, correct? But wait, I mean they literally put crime scene tape around the car, and they didn't put crime scene tape around his body. So I'm just saying, like, it's literally an argument right there. I mean, it's all ridiculous, but on face value, you literally put crime scene tape around the SUV.
Yeah, they totally did. They totally did.
So how is that not a crime scene?
I mean, I guess
just as the excuse to throw out there. I mean, it literally is.
If they're claiming, well, true, because if they're claiming that the SUV is the murder weapon, well, then it's clearly a crime scene. You know, like
I said, you put tape around it that says crime scene, so you kind of can't. Well, we had it. You know, no.
I mean, not the tape around it is what makes it a crime scene, but like it's not official. You know what I mean? It's just crime scene tape. It's you put a barrier of it so nobody would touch it. But the fact that it is the alleged murder weapon, well then, yeah, it's a fucking crime scene.
Yeah, I just think it's there's so many things to go over, and it's way over the mountain in the woods. I mean, at this point, it's just way too over the hill in regards to, who's in on it and this and that, and the feds.
So
and
crazy that it's still going on. Like, it's just so crazy. and it's
and
coming
their
to
motion.
It's coming to a head.
Sorry, sir.
It's coming to a head. Like it's getting wild. Like gloves are off. People, they're swinging hard. You know, everybody is.
Well, especially Brandon's response, which I can't quite tell. Is that the first one that this is the other question. Do they always have Morrissey's name at the top, or is that how they always are? I swear that's the first time I've really seen Morrissey's name at the top in a response.
I don't know. That's
it was a strange.
good question. I
never saw that.
If I noticed it, I wouldn't think much into it, only because he is the DA and it is coming from his office. You know, so
yeah, just hadn't seen it before. But irregardless, just in their clapback is. I mean, we are in. It's got to come to a head here soon with what they've come back with. It's, oh yeah, you know what? We have done all this stuff, and it's all good, and it's in the woods now of something has to break either way, because now all of a sudden it's like, you know, you guys actually altered the video by correcting it, and actually we're mad that the video is not clear, and yeah, we totally didn't turn over stuff, and actually we're still turning stuff over on Monday. So just where we're at now, considering, I mean, the trial was supposed to start on 27th with the continuation. So we're in the strange lands. I mean, the whole thing's been strange, but with this clap back to their motion to dismiss, we're in the realm of, you know, like I said, when you're getting into semantics, talking about, oh no, that wasn't a crime scene. We didn't know anything about the police department, and just, I feel like the knee-jerk response to that motion to dismiss, because there has to be answers to this stuff. You can't, you kind of can't throw out these odd statements. Like I said, the crime scene thing. And granted, I know you say it's tape, but it's literal crime scene tape. So you did wrap it around the car, but I'm just saying legally, that's what you're doing. Because there's hazard tape. You didn't even need to do it, I guess. Apparently,
I gotta be honest with you. I zoned out for like a long time there because I was looking at chat, and then you brought up the crime scene tape again, and I'm like, this dude's still talking about the crime scene tape. I'm sorry, dude.
No, I just meant all the ridiculous stuff. That's about as ridiculous where we're at in a murder thing at this point, to be saying that as one of your main lean-ins. That's ridiculous.
I agree. It is ridiculous.
That's, I guess, my point with that, because it's just like gets run over when it's like, well, it clearly is. So what I'm getting at is, if you're putting that actually in your motion to deny this or whatever, that's about as ridiculous as you can get with all what's involved. As police officers and detectives and prosecutors and all these people, to make a statement like that kind of shows, and that's what I mean about the tilt that has to be coming.
Yeah.
Because that's about as down in the semantic dirt as you can.
And I just think that Bev is hell bent on this going to trial on April 1st, you know, and like,
what's up? Did she have like a thing against Weinstein?
She's just,
is that what it is?
No, you mean Weinberg?
No, I was joking, because my wife, it's like, because Alan Jackson represented Harvey Weinstein. Oh, and everybody's like some just totally left field hard on she has about this.
That's his job, man. You know what I'm saying? Like, it's what
his job's Karen Reed too.
That's his
He
job.
doesn't seem to give a shit.
You know.
But anyway, yeah. Sorry about the crime scene tape thing. I just, like I said, I think it's the hilarity of it and the definition of it. It's just kind of like it for something so serious, the semantic with something like that in an actual motion is pretty. I mean, a lot of stuff's pressing it. But it's like, oh, you know what? The murder weapon? No. That's all good. It's strange. So I just thought it was one of those things that just stands out like a sore thumb, and it's completely weird.
You're right. And she's pointing out, like, it's just a bunch of fucking bullshit word salad. And it shows how disingenuous they are when they care more about the wording of things than they do about the fact that they supposedly lost Sallyport footage evidence. Right. And they've had it, like, they've had it since June of 2023, dude.
Yeah, I guess we'll leave it at this motion. If you read their clapback, if you really look through it, this might be that tipping point. You know, knee-jerk reaction to clearly it's just filled with it. And they're going to have to answer for it. And if she's like, you know what, we don't need an evidentiary hearing, and we're just going to, do you know what I mean? I feel like the dam's going to break with that.
Yeah.
Like I said, the whole thing's filled with strange, a lot of it's deep legal cuts. And especially if you look at the stuff they're trying to cite for what Brennan's, if you look at the laws that they keep citing, it's really off compared to what the defense cites in their like laws for their basis of argument.
Right.
And then when you see what they're willing to put out there, just that file being in the thing, that's Baldwin shit right there with the, oh, well, I mean, some police guy had it in a Nike box. And we were just like, everything.
The defense boldly claims that the surveillance footage video of Mr. Brian Higgins in and outside the Canton police station proves that he perjured himself before a federal grand jury. This claim is extremely prejudicial and false. How? In support of his claim,
exactly.
It's documented. It's in a transcript. It cites the.
Well, this is why I feel like this might be the thing. I mean, Bev's not gonna. Well, there's got to be a point, like the lady just said. We've all seen it. There's just got to be a point real soon that she just can't keep going. It's all good. She just can't. I mean, she can. Everyone says she can. She can. She can. We're really getting into and the whole thing's ridiculous. But we're now over the mountain. A lot's been laid down.
Yeah, there's got to be some sort of reprimand for Judge Bev's behavior. Like there has to be. There's got to be someone that has an authority over her that can hold her accountable for just robbing Karen Reed of her rights.
Because if they just dunk on this and just say move on, it's like, okay, well, I'm not sure about that. One thing else I'll add on that have you ever talked about? Is it strange how they're going to federal court? Is it strange how, like, I mean, I know Marty's her appellate attorney who's going to go into that. Is it strange for Alan Jackson and Yannetti to have been pro hoc vetoed in and are going to go there too?
I wouldn't know. That's a good question.
Because, sorry, I was just going to point out. So it's supposed to be a conference, and when they have these things, what I was hearing, it's really they're going to be discussing what was in the motion, and it's pretty much what's on the law. So if that would be her appeal, they'd be listening to Marty and whoever else is their appellate attorneys. And I just thought it's so strange that Jackson and Yannetti have been pro hoc vetoed into the appellate hearing, which possibly during this conference, if they're going to be fit.
I mean, I couldn't tell you. I honestly couldn't begin to really tell you, but like with my very limited knowledge, with my very limited understanding of the law, I would speculate and wonder. I at least ask the question that is it because they were contacted by those jurors? And maybe that's why they want to be heard.
Or because that's the strange thing. And I just wanted this to float around for maybe other people to conversate, because I haven't even seen it mentioned. From it, what it seems like, though, during these conferences, and this is just for a hope for Karen, that maybe when the doors open, this is your chance. Yeah, they didn't mention a lot on paper, but this might be your chance of sitting across from the table where you can actually just start telling them, showing them stuff. And I just thought it's so strange that Jackson and Yannetti were, pro hoc vetoed in, which gets them in the door. Which I'm just saying, hopefully that, because it is rather strange that they are going to that, when basically they're supposed to just be talking to Marty and going over the law. So hopefully that's one. I don't see anyone mentioning it, and I thought that's super strange because they are criminal defense attorneys. They should be really going to that thing. So hopefully that's a good sign of.
I'm sure that there's a reason for it. I mean,
no, in a good way.
I haven't read it, so I mean, is there a reason in it, in the pro hoc vice filing? That
no, that's just that. No, there isn't. That what I mean is that means they can go into the.
I mean, LaFerrio's saying it's as simple as Karen wants her defense team there, and that's it.
I gotcha.
I mean, I don't blame her.
Well, let's hope. I mean in a good way. Let's just hope when you're sitting across from the feds that you can really just kind of like especially with kind of what, like, hopefully they're sitting across from someone that they can mention all this shit and be like, look what happened with Brennan this past week. You know, look at the cutting off the, you know, the whole, we're pausing this, just all the events.
Right.
Hopefully, are you going to be able to sit across from someone and kind of have the ear, you know?
Right.
And that's what it brought to my mind. So hopefully, because that's what I mean with this comeback, it's like, at this point, it's some Game of Thrones shit going down. Jackson and them guys, which obviously they kind of started clapping back, but apparently they need to really.
It's so crazy.
They're going to have to. They're going to have to get dirty because that's
this whole
not dirty,
thing
but
is a fucking witch hunt, man. It's insane.
It is.
And,
it is.
And it's totally like throw the person in the moat, hogtied, and if they manage to get free and survive, they're innocent. You know.
Well, in Massachusetts, does anyone ever bring up the witch trials and stuff and jokingly that the Massachusetts? I mean, if you really look at their history, it's like
surprisingly that doesn't come up much. That, to my knowledge,
it's their history,
right?
It's Massachusetts is grimy as shit.
Sure.
I mean, they probably already wish they would have hit her in the head with a rock, you know, like straight up.
Wow.
But Massachusetts' history is gnarly, dude.
Yeah. No, I know.
And
I mean, it's one of the oldest. Yeah, it's one of the first.
Kind of being joking, but it is strange. But anyway, I know it was a little bit all over the place, but I just wanted to, where I had started to drop that in there because it's like, it's almost lampoonish on their clap back to the motion. And like I said, there's all of it.
The whole
you look
thing,
at through,
dude, everything fucking Brennan does is a fucking show. It's insane.
Yeah.
He just lies, and he does it with such, you know, it's crazy. Like with conviction, it's insane. Never seen anything like it.
Well, and I'll leave off on this, and I've never seen no one point this spot, maybe, but just how when we get into the absurd of this after what Brennan did and what Alessi points out in open court that you can't argue with what he did, that she's going to have each of them stand up and look at them. I mean, to make each one of them stand up and like kiss the ring almost. Tell me, what did you know? And Elizabeth Little, you know, to make them do that, so strange. Like knowingly,
it's very
what just happened.
Yeah, it's very bizarre. This whole thing is extremely bizarre. Like, I mean, I know that Karen Reed's defense team have never seen anything like this either.
Well, that's what I mean. They like little kids stand up and tell me, what did you know when? It's like, is this really happening at this point in the game?
Yeah.
So, and I just wanted to point out everyone, but it's like, we're really absurd. Everyone's like, this whole thing's been absurd, but we are actually, with these motions, the motion to dismiss and their response, we are actually in the absurd openly, like verbally on paper.
Yeah. Yeah. Like it's just in your face absurdity.
Exactly.
You know? Like,
and that's why I was hoping. Sorry, I didn't mean to talk over you. I just wanted to come in because I know a lot of people say that one angle, but it's like, you know, not, you know, kind of like the bird's eye view of it. And it's like, wow, this is where we really are. Like actually on paper and motions, the stuff that we've been leading up to is to this motion. I thought y'all guys were good. You haven't done anything wrong, but yet this motion fucking, oh yeah, dude, we're hella wrong. But you know what? They're wronger.
Yeah. This is just, it's crazy. This is the craziest thing I've ever seen. Bev is, I mean, just the fact that they're even trying to, like, the question of whether or not Jackson remains in the case is absurd.
Can I point on this too? I think, now let me ask this. I think
grave
the whole
concern.
Well, last week was clearly there's no way that coincidentally, you know, the full interview drops on Monday, where he's clearly saying a lot and Karen says the power thing during her interview. There's just no way that whatever this thing was, and I really think the whole reason that they did this, because there was a reason they did it and she allowed it. I think it was just to fucking destroy Arca on the level that as of now, Arca is irreparably harmed in regards to Jackson payment. Just they've got some wounds where they're bleeding now in the public sphere.
I mean, the Commonwealth,
they're tainted.
They
tainted them pretty bad.
Brennan kept filing these stupid motions, and it was costing and bleeding Karen Reed money through her defense. But the thing is that the defense team, none of them are actually taking any payment right now. And it was just recently revealed. And all of that is just going towards expenses, such as like experts, investigators, things like that. Now, excuse me. Now that Brennan realized this and found out, now he has to just try to sabotage the defense instead of trying to bleed Karen Reed of money, which is realizing, oh, well, it's not happening. That plan's not working because they're not taking payments. So she has the money for, as long as we keep supporting, she'll be okay for experts and things of that nature. But now that strategy tanked, it's plan B. Plan B, sabotage the defense. Plan B, try to cut the defense, get Dylan Jackson out of there.
God, I know everyone says that, but oof. Well, I just don't even want to. I just don't even know if that's going to happen. Like I said, I think the main goal was to just wreck Arca. Because now, can you imagine what this guy's going to in front of the jury? Because see, he knows from the interview with Ronnie how important, if these guys knew that Arca, forget the Fed part of it, but that they were just, what they did was what they did, and the Feds were involved. Well, he went full blower that there's this murky relationship. So the whole thing, I think, was just to really just put a wound on Arca in that, because he's just going to be cross-examining, and now he opened enough of a door for himself.
And that's been his strategy too, is just trying to, he's gone after the one defense expert after the other. Because what he's trying
but now
to
he
do,
did it. What I mean is,
it's it's a simple MO that Brennan has here, which is, I don't have a case against Karen Reed, so therefore my strategy is to destroy her defense. So,
but what I mean is, with the Arca guys, before he did that, because like with
the Arca guys, like he was trying to cut the Arca guys too. That's Karen said herself, it was 95% of her defense, so that's why he went after the Arca guys.
Well, that's what I mean is, like, I don't even think like actually pulling Jackson off. I think it was a backdoor way, because the only way that they could have done anything is if they ended up having what's it called, the like what they did with Marie Russell.
No, it was a two birds with one stone. It was to get rid of Jackson and the Arca testimony. That was the whole purpose of this grave concern bullshit show that we saw. That was the strategy. Well, you mean
to actually get it out, like to actually, because he keeps saying he didn't want them out, right? Because they weren't going to be able to actually do that. That's what I'm getting at now. Like, there's no way she could have made a decision to be like, nope, these guys can't testify. So there's no way they would have been able to get the testimony out.
There's no way she could have done that. Of course she could have done that.
How would they have had to have one of those? What's it called? Where they bring them in?
Well, she's the judge. I mean,
she could have just said, I don't want them in before any of this came out. She could have just literally just said no.
Yeah.
Okay.
That's the
I thought there had to be.
That was the whole point, is that they were trying to argue this, and then Brennan's whole argument was this insane accusation that the defense lied to the court about payment to Arca. And so that's why they had Alessi argue.
I got that. I just meant before that happened, that they would have had to have she couldn't have just said, like I'm saying, before they revealed this, she couldn't have just said that they aren't testifying. That's what I'm getting at, right? They would have had to have the thing they did with Marie Russell, bring them in. leading up to before this happens, that's where
the voir dire, yeah, but
and that's where what I'm saying, and that's where Brennan was leading up to before this happened with the motions of I think I'm gonna right. So if this little stunt didn't go down, the only option would have been to voir dire him, bring him in, sit him down, and try to figure out a way to say, nope, you're out of here, correct?
I mean, that's what you would expect, but at the same time, I mean, maybe I'm just arguing semantics here, but Judge Bev, if she thinks that Brennan, in theory, if she thinks that Brennan presented a strong enough argument, she could just make the decision, I'm not going to include the ARCA experts.
Yeah, I gotcha.
You know what I'm saying? She has the power to do that. So I'm saying, like, the under hypothetical circumstances, if Brennan were to have given her what she felt was a compelling enough argument before even the need to voir dire him to exclude them, then she would have done it. You know, she could have. She has the powers. It's not like she can't do it without doing a voir dire. There's nothing telling her. There's case law that she could cite, that they could cite, you know, and they can write a motion to object to it, I guess.
Yeah, I see.
I
guess I apologize. I was just more getting to the point of by doing this though, they have before this occurred, they've just damaged ARCA period in regards to because he would have been aware of what that Ronnie guy said. And I'm just meaning after this unfolds, now you're just going to be able to spend so much freaking time with this, you know, because it's like, well, let's not get them out from in front of the jury. No, we want to put these guys in front of the jury because now we get to spend all our time cross-examining these dudes about payments. And oh, wait, you're sending email. Do you see what I mean? Like, that's the stage that's been set. It's like, oh man, we do want these ARCA guys in front of because we're going to spend all our time doing this. Ripping them apart. Yeah. And that didn't exist before last week. None of that existed.
But Bev doesn't want that to happen because she is hell-bent on this case, on this trial starting on April 1st.
Yeah.
So she's going to do everything she can to avoid voir diring anybody. You know what I mean? And it's
well, that's what I was kind of getting at.
Brennan that's doing it. You know what I mean? Brennan's the one who's filing these motions to exclude these experts. So it's like,
yeah, it's strange. I just felt like, I mean, it's all good. There's just so many things that are brain breaking in regards to this
whole thing. Everything that's happening. Yeah, this thing is like wrong. Everything about it.
Yeah, if you go down one rabbit hole, your brain starts breaking, and then you go down another one, and it's like, how can there be so many holes from just one lady who apparently was drunk, who may or may not, if at worst case, did whatever you're accusing her, and all this other madness just coincidentally can even be possible.
Yeah, it's crazy.
Yeah, but anyway.
All right, Patrick.
Took up a little too much time.
No, you're fine.
All right, bro.
I enjoyed it. Thanks.
Later.
Later. All right, I'll take one more. Call it a night. Justice for Whitey. Get the fuck out of here.
Call from.
You're on. Who am I speaking with?
Hey, Will. It's Deanna.
What's up, Deanna?
Hey, man. I'm so glad I got a hold of you.
Right on. I'm glad you did too. What's up?
I had to add that Judge Cannoni, Brennan, Lolly, and the other chick.
You want to turn down your device in the background there?
Got it. Got it.
Appreciate it.
I thought I had. Anyways, I just wanted to say, yeah, Judge Cannoni, Lolly, Brennan, and who's the other chick that sits with them at the table?
I forgot. I don't know.
Anyway, they need to get in line for another type of work because they're ruined from here on out.
I mean,
in my opinion,
I mean, maybe because this is
maybe.
Well, because the thing is like, how high does the corruption go? Is the question. You know.
Right. But there are just so many.
Her name's Laura McLaughlin. Thank you, chat. Appreciate you.
There you go. But there's just so many in Massachusetts that understand what Karen's going through and have been through what Karen's going through and couldn't afford to make a case for themselves. So I really do. I think they're history. I just do.
I mean, yeah, because I'm sure that there's going to be some civil blowback for the Commonwealth after this.
Absolutely.
I mean,
Absolutely.
this is just going to get fought on and on and on. I'm here for the long haul. Period.
Right.
Like,
right.
That's it. As long as this is going on, I am here speaking out about it because I can't get my head around it, and there's no way I'd be able to sleep not seeing this through.
Absolutely. And I am right behind you guys. And I love Only Man involved in the whole thing.
Yeah,
I love her to death.
She's great, isn't she?
Yes, she is. Absolutely. Great interview last night with Annie Deb.
Yeah.
Yeah. She's a diamond for sure.
She's definitely a gem. Most definitely.
But yeah, for another thing, I don't see how, they weren't, I'm sorry, that they didn't get the video and stuff, how they didn't get slapped around for not getting the video to the defense in proper time.
That's what I'm saying. Is like Bev she got just a whiff of blood of Alan Jackson. She got just a whiff of Alan Jackson's blood, and she went, got super excited because she thought she had him. But where's all this outrage for all of the fuckery with the discovery since pre-trial of the first trial? Where's the outrage in what the misconduct that the Commonwealth has engaged in?
And so when it comes to all that, as far as that she's overlooked and she should have addressed, is it the feds or whatever that will be the ones that will smack her around or what?
I don't know.
I don't know.
I couldn't answer that for you. I honestly don't know.
Yeah,
I mean,
you know what I mean.
If she's breaking federal law, then
there you go.
Then we can hope that the feds will intervene and charge her and indict her with something. Because what she's doing, is blatantly violating Karen Reed's rights. It's what she's doing. I mean, I don't see any other way around it. Like, it's not like it's a theory. Like, I don't know if she's doing that or not. Like, we're watching her do it. We're watching her do it. I've been watching her do it for well over a year. Like, it's consistent. It constantly happens.
Right. I've been there with you guys. But yeah, I just drives me nuts. I know it drives a lot of people nuts too.
Yeah.
It's crazy. Crazy.
All right.
But I just wanted to add my 2 cents. I appreciate you, Will, so much.
Thank you.
Enjoy your show.
Oh, thank you for watching. I appreciate it.
All right. God bless.
Bye-bye. You too.
Thank you.
No, that's it for me, folks. That's it for me, folks. Taking down the banner there. People, You're absolutely fantastic. Thanks for hanging out with me. I really appreciate you guys. I hope that if you're new subscribers, you're enjoying the channel, and I hope that you continue to enjoy the channel. I enjoy hanging out with you guys. It was a fun live. I enjoyed it. And maybe I'll go live tomorrow. I don't know. Maybe. Not sure. But yeah. Thank you guys for all the support. Amazing. You guys are unbelievable. And again, congratulations to Mazza Media for raising over $4,000 for Karen Reed's Defense Fund yesterday. Everybody who donated, you guys are fantastic. Thank you guys for that, supporting Karen and Mazza. And guys, that's going to be it for me. I love you guys very much, and we will do this again very soon, my friends.